Hello viewers, welcome. Today we will discuss the Constitution of India. The objectives of the topic are to understand the concept of constitutions, to trace the historical aspects of the Constitution of India, to analyze the salient features of the Constitution, and to acquaint oneself with the present status of the Constitution of India. The Constitution of India is one of the most progressive constitutions in the world. Drafted between 1946 and 1949, our Constitution is the fundamental and supreme law of the land. It contains many unique provisions regarding the governance, rights of the citizens vis-à-vis the power of the state, and other significant components. Since 1950, the Constitution has faced several challenges and has withstood the test of time. Meaning and evolution of constitutions. A constitution is the fundamental law of the land. It is also known as the supreme law of the land or supreme lex loci. Constitutional law is the study of fundamental laws that govern the scope of powers and authority of various bodies in relation to the creation and execution of other laws by the government. A constitution binds governments, limiting the context in which rules may be created, interpreted, and force may be applied. Of those nation states that do have constitutions, not all are considered strictly written constitutions, as the laws that govern such issues may not be consolidated into one single constitutional document or instrument. The constitutional law may be fact of interpreting a variety of texts which may also be informed by history, custom, and unwritten constitutional conventions. We can compare, for example, the written Constitution of the United States with British constitutional law, which arises from multiple sources including Magna Carta, the common law, and other customary sources. In some countries, the Constitution is known as the basic law. One of the key tasks of constitutions within this context is to indicate hierarchies and relationships of power. Thus, for example, in the case of a unitary state, the Constitution will vest ultimate authority in one central administration and legislature and judiciary, though there is often a delegation of power or authority to local or municipal authorities. Whereas when a constitution establishes a governmental structure in the nature of a federation, it will identify the several levels of government coexisting with exclusive or shared areas of jurisdiction over law, making application and enforcement. The Constitution lays down the basic structure of government under which people are to be governed. It establishes the main organ of government, the executive, the legislature, and the judiciary. The Constitution not only defines the powers of each organ, but also demarcates the responsibilities. It regulates the relationship between the different organs and between the government and the people. The Constitution is superior to all other laws of the country. Every law enacted by the government has to be in the conformity with the Constitution. The journey of modern written constitutions started with that of United States of America in 1787. the introduction to Constitution of India. It is said that ignorance of law is no excuse. The same can be said with greater force in case of Constitution of India, which is the supreme law of the land. Every citizen is expected to know the fundamentals of our Constitution, considered to be the largest written democratic constitution in the world. The Constitution of India, framed by a galaxy of legal luminaries and statesmen headed by Dr. B.R. Ambedkar, including Pandit Nehru, K.M. Munshi, Sardar Patel, and H.C. Mukherjee, has withstood the test of time during the last 6.5 decades of its working. In spite of 101 amendments, advent of coalition government and emergencies, the Constitution has successfully retained the basic features such as secularism, social justice, and parliamentary form of government. The judiciary has played an important role in upholding the spirit of the Constitution and ultimately the constitutionalism. It has invoked the power of judicial review and adopted the process of judicial activism to expand the contours of the Constitution without disturbing the basic structure envisaged by the framers. Public interest litigation, a judge-induced and judge-led phenomenon, has served the cause of poor, destitute, women, voiceless prisoners, and victims of environmental and pollution with distinction. Many judges like Patanjali Shastri, Gajendra Gadkar, Koka Subbarao, H.R. Khanna, V.R. Krishna Iyer, P.N. Bhagwati, O. Chinnappa Reddy, and M.N. Venkatachalaya have contributed a vast reservoir of jurisprudence for the development of constitutional law in India. Justice Kuldeep Singh stands out among the recent Supreme Court judges, a green judge, who contributed to the causes of environmental protection immensely. As already mentioned, the Constitution, being the fundamental or supreme law of the land, must be known and understood by every citizen. Study of the Constitution no more remains the monopoly of lawyers, political scientists, and public administrators. It is a law which has to be understood even by a common man. By exposing children to the dynamics of Constitution at a very young age, we can expect them to become responsible citizens in the future. Further, it also equips them with the knowledge of basic framework of the fundamental rights which are entitled to and the fundamental duties to be discharged by them. World War II in Europe came to an end on May 9, 1945, after the Labour Party had come in power in England. It was announced that a mission of 3 cabinet ministers would be sent to India to explore the possibility of an immediate settlement of the Indian problem. This team of ministers was called the Cabinet Mission. The Cabinet Mission discussed the framework of the Constitution and laid down in some detail the procedure to be followed by the Constitution drafting body. Some of the basic principles on which the Constitution of India was based were as follows. There should be a union of India embracing both British India and Indian states. The Union would have an executive and legislature constituted from British India and state representatives. All subjects other than the Union subjects and all residuary powers would be vested in the provinces. The paramountcy of the Crown over the Indian state was to lapse, and an interim government was to be set up having the support of the major political parties. The election for the 296 seats assigned to the British Indian provinces were completed by July-August 1946, with the independence of India on August 15, 1947. The Constituent Assembly became a fully sovereign body. The Assembly began its work on 9th December 1947. The Constituent Assembly. The people of India elected the members of the provincial assemblies, who in turn elected the members of the Constituent Assembly. The Constituent Assembly had members belonging to different communities and regions of India. It also had members representing different political persuasions. Jawaharlal Nehru, Rajendra Prasad, Sardar Patel, Maulana Abdul Kalam Azad and Shyam Prasad Mukherjee were some of the important figures in the assembly discussions. There were more than 30 members of the scheduled classes. The Anglo-Indian community was represented by Frank Anthony and the Parsis were represented by H.P. Modi. The chairman of the Minorities Committee was Harindra Kumar Mukherjee, a distinguished Christian who represented all Christians other than Anglo-Indians. Constitutional experts like Alladi Krishnaswamy Iyer, B.R. Ambedkar, B.N. Rao and K.M. Munshi were also members of the assembly. Sarojini Naidu and Vijay Lakshmi Pandit were important women members. Dr. Sachidanand Sinha was the first president of the Constituent Assembly. Later, Dr. Rajendra Prasad was elected president of the Constituent Assembly, while B.R. Ambedkar was appointed the chairman of the drafting committee. The Constituent Assembly met for 166 days spread over a period of 2 years, 11 months and 18 days. Its sessions were open to the press and public. The Objectives Resolution. The underlying principles of the constitutions were laid down by Jawaharlal Nehru in his Objectives Resolutions on 13th December 1946. India is an independent sovereign republic. India shall be a union of erstwhile British Indian territories, Indian states and other parts outside British India and part of the Union. Territories forming the Union shall be autonomous units and exercise all powers and functions of the government and administration except those assigned to or vested in the Union. All powers and authority of sovereign and independent India and its constitution shall flow from the people. All people of India shall be guaranteed secured social, economic and political justice, equality of status and opportunities before law, and fundamental freedom of speech, expression, belief, faith, worship, vocation, association and action subject to law and public morality. The minorities and backward and tribal people, depressed and other backward classes would be provided adequate safeguards. The territorial integrity of the Republic and its sovereign rights on land, sea, and air would be maintained according to justice and law of civilized nations. The land would make full and willing contribution to the promotion of world peace and welfare of mankind. The present Constitution of India, drafted by a drafting committee of Constituent Assembly headed by Dr. B.R. Ambedkar, was adopted by the Constituent Assembly on 26 November 1949, which is celebrated as the Law Day as well as the Constitution Day. And it came into force on 26 January 1950, which is celebrated as the Republic Day. Dr. Ambedkar was assisted by 11 subcommittees on various subjects like union powers, fundamental rights, and judiciary. It has many unique features that suit the Indian social, economic, and cultural factors and environment. The Indian Constitution has many striking features. Although it is said that it is a combination of features borrowed from different constitutions, the fact remains that it has a unique characteristics especially designed to suit the modern India and Indians. The most striking and salient features of the Constitution are discussed. Modern Constitution. Indian Constitution represents modern Constitution as it was drafted in the middle of the 20th century. The framers of the Constitution had benefits of looking at the many leading constitutions of the world before drafting the present Constitution. The Constitution thus drew upon a rich fund of human experience, wisdom, heritage, tradition in the area of governmental process in order to fashion a system suited to the political, social, economic conditions of India. Nonetheless, the influence of the US Constitution on the federalism and fundamental rights of the Constitution of UK on parliamentary form of government of the Irish Constitution, on the directive principles of state policy, and of the Russian Constitution on the fundamental duties enshrined in the Constitution, established the fact that our Constitution has imbibed in itself some of the most important features of other leading constitutions of the world. In spite of such influences, it retains many unique features typical to India. Unique blend of federalism and Unitarianism. The constitution of modern times are generally classified into either federal or unitary constitutions. A federal constitution is that constitution which incorporates written constitution, rigidity, division of powers, independence of judiciary, and supremacy of the Constitution. The Constitution of the United States of America, brought into force in 1789, is the best example of a federal constitution. On the other hand, a unitary constitution is the one which provides the concentration of governmental powers in the center and subordination of states to the center. Further, it is flexible and the judiciary is not expected to resolve the disputes between the center and states as an empire, as in the case of federal constitutions. The predominantly unwritten Constitution of United Kingdom of Great Britain is the best example of a unitary constitution in the world. With regard to the Indian Constitution, it imbibes both the federal and unitary characteristics. It is mostly federal and remains so during normal times. However, some features like the Parliament's power to form new states, emergency provisions, Parliament's power to make laws on state subjects under certain circumstances make the Constitution of India unitary. Thus, there is a unique blend of unitary and federal features in the Indian Constitution. Written Constitution. Our Constitution is a lengthy, elaborate and detailed document. Originally, it consisted of 395 articles arranged under 22 parts and 8 schedules. Today, after 101 amendments to it during the last 66 years of its working, it has about 450 articles and 12 schedules. It is probably the longest of the organic laws now extant in the world. The Constitution details with organization and structure of not only the union government but also of the state governments. It also deals with a detailed scheme of center-state relations, fundamental rights, directive principles of state policy, fundamental duties, emergency provisions, safeguards to civil servants and freedom of interstate trade and commerce. However, in spite of its lengthy size, the Constitution does not spell out certain principles relating to formation of coalition governments and dissolution of Lok Sabha when recommended by the Prime Minister who has lost majority in the Lok Sabha. Preamble. The Constitution of India has a unique and elaborate introductory statement in the form of a preamble. It clarifies the source of the Constitution, i.e., the people of India, and also the kind of polity sought to be established by it, i.e., sovereign, socialist, secular, and democratic republic. Even though the preamble does not grant any power, it gives directions and purpose to the Constitution. The objectives of the Constitution to secure to all citizens equality, justice, liberty and fraternity are clearly outlined in the Constitution along with the unity, integrity and sovereignty of the country. Fundamental rights. The Constitution in its Part 3, constituting of Articles 12 to 35, recognizes the fundamental rights of citizens and others. They include the right to equality, right to freedom, right to life and personal liberty, right to education, right against exploitation, right to freedom of religion and conscience and cultural and educational rights. Originally, the right to property was a fundamental right, but it was repealed in 1978 by the 44th Amendment. The right to free and compulsory education to all the children between 6 and 14 years was added under Article 21A as a fundamental right through the 86th Amendment made in 2002. A unique feature of the Constitution is that it also guarantees the right to enforce the fundamental rights as a fundamental right in the form of right to constitutional remedies. Apart from above enumerated fundamental rights, the Supreme Court and other courts have recognized many implicit fundamental rights like the right to health, right to privacy, right to free legal aid, and the right to environmental protection. Directive principles of state policy. Part 4 of the Constitution incorporates certain directive principles which are not enforceable in a court of law. However, they are recognized as fundamental to the governance of the country and are recommendatory in nature. The direct to the state to establish a welfare state and to render socio-economic justice to all citizens of India. The idea of such non-justifiable rights was borrowed from the Instrument of Instruction of the Government of India Act 1935 and also from the Irish Constitution. There are about 20 directive principles contained in Articles 36 to 51, including principles relating to minimization of economic inequalities, prevention of concentration of wealth in a few, right to work, education and health, uniform civil code and protection of natural environment. These principles are relied upon in making the policies of the government. The courts also interpreted many of these directive principles as fundamental rights in recent times. Fundamental duties. Even though the enjoyment of fundamental rights is not corresponding to discharging of duties, the Constitution contains 11 fundamental duties in Part 4A of the Constitution. They are imposed on citizens and can be enforced if there is an enabling law to do so. These duties go a long way in making the citizens responsible and civilized. They include the duty to respect the national anthem and the ideals of freedom struggle, to protect the public property, natural environment and dignity of women. They also exhort the citizens to strive for excellence in every sphere of human life and to develop spirit of inquiry and a scientific temper. The last fundamental duty is of the parents and guardians to provide opportunity to their children and wards for education between 6 and 14 years of age. Parliamentary form of government. The concept of this form of government was borrowed from the British Constitution. It denotes that the Council of Ministers is responsible to the directly elected legislature and that the real executive power is vested in the Council of Ministers headed by the Prime Minister. The President, though enjoys significant powers, has to act in accordance with the aid and advice of the Council of Ministers except in few cases. He remains only the de jure as per law executive, whereas the Prime Minister is the de facto, in fact executive. Independent judiciary. Of the three organs of the state, the judiciary is independent of the influence of the other two organs, vis-a-vis the legislative and executive. It can be seen from the procedure to appoint Supreme Court and High Court judges as evolved by the judiciary itself since the year 1993 in form of collegium system. The security of the tenure enjoyed by them up to 65 and 62 years respectively, and the powers exercised by the higher judiciary, including the power to punish for contempt of court and also the power of judicial review. The judiciary is independent also for the reason of federal character of India, whereas it has to resolve disputes between the center and the state and also between states as an impartial umpire. Division of powers. The Constitution being federal in nature contemplates a clear division of legislative, administrative, and financial powers between the state and the center. The scheme of such a division appears to have been borrowed from the Canadian Constitution. However, the center enjoys a predominant position in spite of such divisions of powers in view of the strong centralizing tendency. For instance, in lawmaking, as per the original Constitution, the Union legislature can enact laws on 97 central subjects, 47 concurrent subjects, and also on 66 state subjects. Further, if there is a conflict between a central government and state law on a concurrent subject occupying the same field, the central law prevails. Emergency provisions. Article 352 to 360 of the Constitution provide for three kinds of emergency that can be declared under different circumstances. They are national emergency, which can be declared by the President's written advice of the Union Cabinet on the actual or threatened war, external aggression of armed rebellion. State emergency, which is also called the President's rule, that can be imposed on the ground of failure of constitutional machinery in a state. And financial emergency, which can be imposed on the ground of threat to the financial stability or credit of the country. Partly rigid and partly flexible. Our Constitution can be amended in accordance with the procedure contained in Article 368 of the Constitution. So far, till October 2016, 101 amendments have been made to the Constitution during the last 55 years. Till 1973, there was a presumption that the Parliament had unlimited powers to amend any provision of the Constitution. However, the Supreme Court in the case of Keshavananda Bharati versus State of Kerala, AIR 1973 SC 1461, has declared that even though the Parliament has unlimited powers to amend the Constitution, it cannot amend the basic features of the Constitution like parliamentary form of government, adult franchise, secularism, independence of the judiciary, and power of judicial review. In that sense, and also in view of the rigid procedure to amend certain provisions like division of powers, election of the President, and jurisdiction of the Supreme Court and High Courts, our Constitution can be called partly rigid and partly flexible. Apart from the above features, the socialistic character of the state, the secularism, all India services, special provisions for scheduled caste, scheduled tribes, and other backward classes and minorities can also be cited as the salient feature of the Constitution.